I'm Art Sterling, and I've been practicing probate and estate law in California for 17 years. In that time, I've seen families torn apart by grief and greed, but few cases have stayed with me like Evelyn Reed's. It was a scorching August afternoon, one of those days when the air conditioning in my downtown Los Angeles office felt like a godsend, when Evelyn first walked in. She was a woman in her early 70s, her posture still graceful, but her eyes held a profound weariness, a decade of quiet suffering etched into her face. She sat across from me, hands clasped tightly in her lap, and began to speak in a voice barely above a whisper. Her brother, Robert Reed, a successful real estate developer, had died suddenly 10 years prior. His entire multi-million-dollar estate, including his beloved Malibu beachfront home and a portfolio of investment properties, had fallen into the hands of a nephew who hadn't seen Robbie in years, all because, according to the nephew, Robbie had died intestate, without a will. But here's the kicker, the detail that made my stomach drop and my legal antennae go up. Evelyn swore her brother was meticulous, a man who planned everything down to the smallest detail. The idea of him not having a will, especially with an estate worth north of $12 million at the time of his death, simply didn't compute. 10 years she'd lived with this injustice, seeing her brother's legacy hijacked, while she herself struggled financially. Her savings were dwindling, and the stress was taking its toll on her health. She came to me not just for money, but for vindication, to honor her brother's memory, to prove that he wouldn't have left her out in the cold. Everything was at stake for Evelyn, her financial security, her peace of mind, and the memory of her brother. Here's what you need to understand about California probate law, because it's central to Evelyn's story. Under California Probate Code, Paragraph 6400, if someone dies without a valid will, which is what intestate means, their assets are distributed according to a very specific pecking order established by the state. Typically, it goes to a surviving spouse, then to children, then to parents, and if none of those exist, then to siblings. This statutory scheme is designed to ensure assets don't just sit in limbo, but it often completely disregards the deceased person's true wishes, especially in complex family situations or when there are estranged relatives. The default rules kick in, and the people the deceased cared about most might get nothing. A valid will, on the other hand, is a legally binding document that outlines exactly how a person's estate should be distributed after their death. It can name specific beneficiaries, appoint an executor, and even include provisions for things like charitable donations or trusts. If a will is handwritten entirely by the testator, the person making the will, and signed by them, it's called a holographic will, and under California Probate Code, Paragraph 6111, it can be perfectly valid even without witnesses. This legal framework explains why Evelyn's case was so critical. For a decade, the courts, relying on the nephew's sworn testimony, had presumed Robbie died intestate. This presumption had the force of law, and overturning it would require not just a missing will, but proof that the will was authentic, executed properly, and undeniably Robbie's. It was a monumental legal uphill battle, but one that could completely rewrite history for Evelyn. Evelyn Reed was a retired high school English teacher, articulate and refined, but the years of carrying this burden had clearly taken their toll. Her hands trembled slightly as she spoke, and her voice, though steady, held an undercurrent of deep pain. Her older brother, Robert, or Robbie as she affectionately called him, was a larger-than-life figure. He'd built a successful real estate empire from the ground up, starting with a single duplex in Santa Monica and growing it into a portfolio worth over $12 million by the time of his death. Robbie was known for his sharp mind, his meticulous record-keeping, and a surprisingly sentimental streak. He was a bachelor, no children, and Evelyn was his only living sibling. They weren't overtly demonstrative with their affection, but they spoke every Sunday, shared family holidays, and had a deep, unspoken bond. 10 years ago, Robbie had a sudden, massive heart attack at his Malibu home. Evelyn was devastated. In the chaotic aftermath, Robbie's nephew, Mark Reed, the son of a long-deceased younger brother, suddenly materialized. Mark was a slick, opportunistic man in his late 40s, a perpetual entrepreneur whose ventures always seemed to fail. He had been estranged from Robbie for nearly 15 years after a disastrous attempt to get Robbie to invest in one of his dubious startups. Yet, Mark quickly asserted himself as the next of kin, who lived nearest, took control of Robbie's home, and within weeks filed a petition with the probate court claiming Robbie died intestate. Without a will, and with Evelyn living hundreds of miles away in Sacramento and still reeling from grief, Mark was declared the sole heir. Evelyn recalled being told by Mark's newly hired attorney that there was no will, Evelyn, we searched everywhere. She was too grief-stricken and unsavvy about legal matters to challenge it immediately. Mark proceeded to sell off many of Robbie's properties, including the beloved Malibu home, and liquidate assets, all under the guise of settling the estate. He never offered Evelyn a penny, even when she later struggled with medical bills. Evelyn finally came to me because a mutual acquaintance, another retired teacher, insisted I was the attorney who could help. She was at her wit's end, living on a meager pension, watching her brother's legacy squandered by a man who had no real claim to it in her heart. She said, her voice cracking, "Mr. Sterling, Robbie would never have done this to me. He promised me he would take care of me. There has to be a will." Her vulnerability, combined with the sheer audacity of Mark's actions, made it impossible for me to turn her away. My initial investigation began not with a bang, but with a mountain of dusty paperwork. 10 years had passed, which meant records were archived, memories faded, and trails grew cold. I started by getting a court order to access all probate filings related to Robert Reed's estate. Mark Reed, represented by Stern & Associates, a firm with a reputation for aggressive defense tactics, had handled the original probate with surprising speed. Their filings were minimal, focused entirely on the intestate presumption. My team and I began digging into Robbie's life, trying to piece together his habits and character. We hired a private investigator, a former LAPD detective named Frank Miller, to track down anyone who knew Robbie in his later years, business partners, neighbors, even his gardener. We also engaged a forensic accountant, Sarah Chen, to scrutinize every financial transaction Mark made in the 10 years he'd controlled the estate, looking for anomalies, unusual withdrawals, or anything that hinted at a cover-up. The process was slow, arduous. Frank hit several dead ends. Many of Robbie's long-term business associates had either retired, moved, or passed away. Sarah found some eyebrow-raising transactions, significant personal expenses for Mark charged to the estate before. The probate was even finalized, but nothing that directly pointed to a missing will. Opposing counsel from Stern & Associates stonewalled at every turn, claiming all relevant documents had been provided a decade ago and that our requests for additional discovery were harassment. They argued we were on a fishing expedition, trying to overturn a settled matter. Their lead attorney, a slick, self-assured man named Richard Sterling, no relation, thankfully, implied I was wasting the court's time and Evelyn's money. He even threatened sanctions. But I wasn't deterred. Robbie was a meticulous man, Evelyn insisted. He didn't just leave things to chance. We expanded our search, poring over old phone records, Robbie's sparse email account from a decade ago, property deeds, and even the inventory of his personal belongings that Mark had filed with the probate court. Among thousands of lines of data, one tiny detail piqued my interest. An old business email from Robbie to a long-retired notary, Mrs. Albright, mentioning final arrangements and securing my last wishes. It was vague, but it was something. I also found an unusual entry in a decades-old safe deposit box log from a bank Robbie used to frequent. It indicated an unusually large box, accessed only once by Robbie about a month before his death, and never again. I shared these leads with Frank Miller, our PI, telling him to focus on Mrs. Albright and anything unusual about Robbie's post-retirement life, especially regarding his personal effects. The breakthrough came a few weeks later when Frank called me, his voice buzzing with excitement. He'd tracked down Mrs. Albright, now in her late 80s, living in a quiet retirement community in Laguna Beach. She had a steel-trap memory for details. She remembered Robbie vividly, not just for the notary service, but for his eccentricities. She recalled him discussing his final arrangements with her, specifically mentioning that he was making sure everything was in its place, somewhere unexpected, and chuckling about it. She'd made a joke about hiding it under his mattress. Robbie, apparently, had replied, "Even better, Mrs. Albright. Something only I would know." She distinctly remembered him mentioning a specific antique roll-top writing desk he prized, a family heirloom with hidden compartments. My heart raced when I heard this. Mark's initial inventory of Robbie's estate had listed miscellaneous antique furniture, and showed a rapid sale of many items just months after Robbie's death, before the probate was fully finalized. This desk wasn't specifically itemized. We immediately filed an emergency motion with the court, requesting an order to track down and search Robbie's antique roll-top desk, citing Mrs. Albright's testimony and the reasonable belief that the missing will could be concealed within it. The motion was fiercely opposed by Richard Sterling, who called it speculative fantasy and a desperate ploy. But Judge Vance, after hearing Mrs. Albright's compelling, detailed testimony in chambers, granted our motion. The antique dealer who had bought the desk from Mark's estate sale a decade ago still had it in storage, untouched. We executed the search warrant, and there it was, tucked away in a cleverly concealed compartment behind a series of small drawers in the roll-top mechanism, a yellowed, sealed envelope. Inside, I found it, Robbie's last will and testament. It was a perfectly valid holographic will, entirely handwritten by Robbie, dated just 3 weeks before his death. It named Evelyn Reed as the primary beneficiary, leaving her 90% of his entire estate, with a few smaller bequests to charities. It clearly stated, "I entrust the bulk of my estate to my dear sister, Evelyn, who has always been there for me, unlike others who only appear when opportunity knocks." The specific language was a devastating blow to Mark Reed. Evelyn was on the phone with me when I called her. She listened in stunned silence as I described finding the will and read parts of it aloud. Then the dam broke. 10 years of suppressed grief, anger, and injustice poured out in an uncontrollable flood of tears. It wasn't just the money. It was her brother's voice, finally heard, finally affirming his love and trust. The courtroom felt heavy with anticipation on the day we presented the will. Los Angeles Superior Court, Probate Division, Department 17. Judge Eleanor Vance, a no-nonsense jurist known for her keen intellect and strict adherence to procedure, presided. The air was thick with the scent of old paper and nervous sweat. Richard Sterling, for Mark Reed, sat at the opposing table, looking far less confident than usual, his face a mask of controlled anxiety. Our first witness was Mrs. Albright, whose calm, detailed recollection of Robbie's comments about his hidden arrangements laid the groundwork. Then came the antique dealer, confirming the provenance of the desk and its journey to his storage unit. But the real star was Dr. Eris Thorne, a forensic document examiner. I led him through the process of authenticating Robbie's handwriting, using known exemplars of Robbie's signature and script from old business documents. Dr. Thorne testified with quiet authority, pointing to unique pen strokes, consistent letter formations, and the distinctive way Robbie formed certain numbers. The ink, based on spectrographic analysis, is consistent with ink commonly used a decade ago, and the paper shows the natural aging patterns expected for a document of its stated age, he concluded, his voice clear and unwavering. Richard Sterling launched into his cross-examination of Dr. Thorne, attempting to cast doubt on the document's age and chain of custody. "Dr. Thorne, is it not true that inks can be artificially aged, and that a skilled forger could replicate Mr. Reed's hand?" he pressed, his voice sharp. Dr. Thorne remained unruffled. While artificial aging techniques exist, the combination of specific paper degradation, ink analysis, and the unique, subtle characteristics of the handwriting itself makes it exceedingly improbable this is a forgery. My analysis indicates a high degree of confidence that this document was written by Robert Reed at the approximate time stated. He then added, "And the meticulous nature of the handwriting and the precise language aligns perfectly with Mr. Reed's known personality, based on other documents I reviewed." Sterling's face tightened. Then it was time for my cross-examination of Mark Reed. He swaggered to the stand, feigning calm, but his eyes darted around the room. I started gently, asking about his relationship with his uncle. He embellished, portraying a close bond that we knew was false. "Mr. Reed, when you took control of your uncle's estate, did you conduct a thorough search for a will, as is your legal obligation as next of kin? I asked, my voice calm but firm. Of course I did. I searched everywhere. There was nothing, he responded, his voice steady, perhaps too steady. Did that search include the contents of every piece of furniture in your uncle's house? I continued, stepping closer to the witness box. Yes, every drawer, every cabinet, he insisted, a bead of sweat tracing a path down his temple. Even the antique roll-top desk with the hidden compartments that you sold off months later to an antique dealer in Pasadena? The question hung in the air. Mark's face drained of all color, his eyes widened, and he stammered, I wasn't aware of any hidden compartments. The desk was just old furniture. His attorney looked absolutely defeated, sinking back into his chair. A valuable heirloom, Mr. Reed, that a man as meticulous as your uncle, according to his own sister, treasured deeply. And you sold it without a thorough inspection, knowing it might contain important documents. I pressed, presenting the manifest from the antique dealer with the sale price. Mark had no answer. He was caught in a blatant lie. Then, the moment. I approached the judge, holding up the yellowed envelope. Your Honor, the plaintiff requests permission to enter into evidence Robert Reed's last will and testament, found in the very desk Mr. Reed here failed to thoroughly inspect. The room went utterly silent. Judge Vance nodded, her gaze fixed on Mark. I read aloud the critical section. I entrust the bulk of my estate to my dear sister, Evelyn, who has always been there for me, unlike others who only appear when opportunity knocks. Mark visibly flinched, his eyes darting to Evelyn, then back to the judge, his composure utterly shattered. His attorney objected weakly. Your Honor, this is highly prejudicial. Judge Vance simply waved it away. The message was clear. The judge retired for a short recess, the courtroom buzzing with hushed whispers. When she returned, her voice cut through the tension like a knife. Judge Vance declared the holographic will found in Robert Reed's desk to be authentic and legally valid under California Probate Code, Perv 6111. She ruled that the prior intestate distribution was null and void. A collective gasp went through the courtroom. The judge then ordered a complete reprobate of the estate, with Evelyn Reed as the primary beneficiary, as per her brother's true wishes. Mark Reed was ordered to return all assets he had unlawfully appropriated over the past decade, including the proceeds from the sale of properties, investment gains, and substantial interest. He was also subject to a forensic audit to ensure full compliance. The total amount, factoring in the appreciation of the real estate and the interest on the liquidated assets, was estimated to be approximately $15 million, a sum far greater than the original $12 million. The judge sternly noted that Mark's conduct would be referred to the district attorney's office for potential charges of fraud and perjury, a separate legal battle he would face. Evelyn, sitting beside me, began to sob, not in pain but in profound relief. She embraced me fiercely, repeating, "Thank you, Art. Thank you." It wasn't just about the money, it was about the restoration of her brother's honor, about justice finally being served after 10 long, agonizing years. Mark Reed, his face ashen, stumbled out of the courtroom, his legal career and reputation shattered, facing not only financial ruin but the real possibility of criminal charges. The 10-year deception was over. This case taught me a profound lesson about persistence and the enduring power of truth. Sometimes, when something feels fundamentally wrong, when a client's gut instinct screams injustice, you have to dig deeper, even if the trail is old and cold. Never give up on the seemingly impossible lead. Robert Reed was a meticulously organized man, and it was that very characteristic that led us to the hidden will. He didn't trust banks with his most personal documents. He trusted his own cleverness and the secrecy of a beloved antique. The broader legal lesson for anyone watching is absolutely critical. Get your will done. Keep it updated. And perhaps most importantly, tell your trusted loved ones exactly where it is. Don't hide it so well that it can never be found. If a loved one dies, be wary of relatives who are quick to declare an intestacy without a thorough, transparent search for a will. Any rush to liquidate assets or sell sentimental items should raise a major red flag. Always consult with a qualified probate attorney immediately. This case was a stark reminder of the lengths to which human greed can push people, manipulating grief and legal loopholes for personal gain. But it also reaffirmed my belief that with enough determination, justice can eventually prevail, even after a decade. Today, nearly a year after the judgment, Evelyn Reed has found immense peace. She used a portion of her inheritance to buy back one of Robbie's original, smaller homes. Not the Malibu mansion, but a charming bungalow in Santa Monica where they spent their childhoods, and has beautifully restored it. She's established a scholarship fund in Robbie's name for aspiring artists, honoring his little-known love for painting, and is finally traveling the world, enjoying her golden years with dignity and a clear conscience. Seeing her thrive, knowing I helped right such a profound wrong, is why I do this job. It's the most rewarding part of battling through the complexities of the law. I've got plenty more stories to tell, so if you have questions about this case or any other legal matters, drop them in the comments below. And don't forget to hit that subscribe button for more dramatic real-life case stories.